Mr. Charles had his final phase of sentencing, and he received a total sentence of 34 months. That's actually 3 months less than the maximum he would have received had he not benefited from a technicality. He was a criminal history B for sentencing purposes, which means he has 2 or more person felonies on his record. He objected to some of the entries contained in the pre-sentence investigation report, where they try to look and see what prior criminal activity you've been involved in. He objected to some of those entries from the mid-90s, from 94, 95, 96, and those convictions were out of Wyandotte County. 11 days after the initial hearing, they sent a letter in the U.S. mail to Wyandotte County to a records clerk asking for the records. Judge Kaufman was not happy about that. If they got that documentation, he would have been an A for sentencing purposes, meaning he had 3 or more person felonies on his history. Because of the nature of the crime, what the victim was going through, those sorts of things all played into that characterization and resulted in the high number on each of the 3 counts. So he basically benefited in getting 3 months less prison time than he would have gotten if they had gotten that documentation. When he is released from prison, because he was a presumptive prison sentence, he will have post-release supervision, which is done through our parole office. He will have that for a period of 12 months where they make sure that he's abiding by the terms and conditions of his post-release supervision, and also that he's following the law, not using drugs. Anything like that could send him back to prison for the remainder of that 12-month post-release supervision time.